Tony Carls. I'm joined here today by attorney Latrice Knighton, partner here at Sterling Law Offices. Latrice, thanks for joining us here today.
I'm happy to be here.
So we're gonna talk about a difficult question.
Okay.
Maybe not for you, but a question that we get online often. So and that question is, can I modify alimony after the divorce has already been finalized? So and here's the scenario. So the scenario is a couple was divorced after a 24-year marriage. Then 5 years later, the wife wants to modify the alimony payments. So is that something that's possible? How would that work? What's the court said about that in the past?
Yeah, there's actually one good case that's right on point to that. It's called Vander Perren versus Vander Perren. Okay. And it's a case, it's a long-term marriage, just like your facts situation here. The parties were married for 24 and a half years. They had 2 kids together. The entire marriage, mom had stayed home and been a homemaker. And that's exactly what her husband wanted her to do. They got married right out of high school. So she stayed at home, raised the kids. They divorced 24 and a half years later. At the time, wife was still unemployed. So they entered into a maintenance agreement where wife was to receive $200 a month in child support plus $175 a month in alimony.
Seems really low. Is this like an older case? When was this?
It's from 1982.
Okay, so a little different than
yes.
2019.
Not something she could really live on now.
Yeah.
Absolutely.
Yeah.
So wife was receiving the child support and she was receiving the maintenance. What happened is that their son, one of the sons graduated, became adult, was able to take care of himself. The other son decided, I want to go live with dad a little bit more time out of the year. Mom was fine with that. So at the same time, she filed a motion to increase her maintenance because even though her son was moving out of the home, she still needed more money to pay for her monthly bills because 5 years after the divorce was finalized, she realized that wasn't an appropriate amount for her to sustain herself. She goes to court. He files a motion to terminate any more maintenance, saying she should be working more. What ended up happening is the court looked at...
Was she not working at all, or what was the...
At the time, she wasn't working at all.
Okay.
She had started during this motion process looking for more jobs. She had long-term shoulder and arm injuries that disqualified her from the typical jobs of housekeeping or being a waitress or being a factory worker because she couldn't lift a lot of things.
Okay.
So she was already well below the average of what most people could make, even in entry-level jobs, because she couldn't apply to many of them.
Okay.
She was able to get a little part-time job as a clerk for a friend's company, so that was really just her way in, even onto an entry-level job because of her physical limitations. And so that was also part of her argument. I can never become self-supporting because of my injuries and because I was out of the workforce for so long. Husband said, I'm done paying. I just don't want to pay anymore. It should be fair that it be terminated. What the court ended up doing initially was actually increasing her support from $175 per month up to $300 and said this will only go for another year unless you file another motion and come back to court. So she did take that increase, and a year later she did file to extend it again. This time the husband did again ask for a termination. What the court did was not what either party actually asked for. They actually increased it back down to $150, which was less than the initial order, okay. And then said, we're terminating it a year from now.
Okay.
So wife was upset with that because husband didn't file a motion to have the support reduced. He just said terminating it, and she thought that it should either be reduced or terminated. She appealed. The court decided that the lower court had made some errors. Okay. First, they didn't look at all the factors in the statute. It only looked at the one issue of whether or not it should be terminated and based its decision primarily on wife, her expenses being as high as they were, and they felt they were inappropriate. They also didn't look at the fact, though, that she wasn't able to become gainfully employed and pay all the bills and maintain a lifestyle that she enjoyed during the marriage. So the court says, you didn't look at this enough. We want you to go back and look at these issues again and determine whether or not her maintenance should be reduced or it should be increased based on those factors.
So it sounds like the first court didn't do a real good job, and they appealed it. find that the court need to re-rule. So what happened after the re-rule?
So the case ended up going back, and wife was able to get a little bit higher support than her second increase was. So it worked out better for her, because it really was. The Court of Appeals looked at the lower court and said, you made a rash decision based on only 2 issues, and you should give a more thorough look at it. And when they did, it actually helped her a lot.
Awesome. So looking back at our original question, which was, can I modify alimony after the divorce is finalized? And then under the scenario where it's 24 or 20 plus year marriage, and a couple of years later, there's still an opportunity to modify it. And it looks like that process probably took a couple of years longer to go through all the appeals and all that kind of stuff. They modified the whole thing even after all that time. So modifications are definitely possible after the fact, depending on the circumstances.
Absolutely.
Awesome. Well, that's Case Law Friday. Thanks everybody for joining us.
Case Law Friday is a Sterling series focused on communicating in layman's terms cases of precedent, statutes that guide decisions, and court procedures important to getting results in family law. Please like and subscribe. We hope these deep dive conversations create clarity, enabling you to better understand the rules that govern how decisions get made in family court.